In the following webinar, Dr. Saccuzzo discusses the issues most frequently tested on essays in the California bar exam in civil procedure, federal civil procedure. So the statistics he talks about are from essays on the California bar exam in the past 20 years or so.
The big issues, it's almost boring. Subject matter jurisdiction's almost always tested, so you're going to need to know the basic rules, and personal jurisdiction is tested very frequently. Preclusion frequently, I'll be talking a little bit more about it, and venue. So now, when you have a fact pattern and you're not sure that if they say the court lacked jurisdiction, you go, well, am I talking about subject matter jurisdiction, personal jurisdiction? Look at your facts. If you have facts that go to domicile, facts that go to principal place of business, facts that go to amount in controversy, especially if the amount in controversy is below $75,000 and that maybe there's an injunction or some request for equitable relief, or maybe two parties, so we might want to have aggregation, then you know that subject matter jurisdiction is your main issue. If, on the other hand, there are contacts, they tell you contacts, defendant entered the state and did this and did that in the state, then the big issue is very likely to be personal jurisdiction. Okay, and I'll come back to preclusion. That's important. It could appear on your bar. Venue, well, the big thing, remember, venue. Where can you sue somebody? Where can you sue somebody? Where they live, okay? All right, so basically in their state or in their county, where they live, or where the harm occurred. So basically, that's where your venue, those are the big venue rules. So just remember that. All right, now, other big issues, pleadings, I'm going to talk about that. Now, on the work product doctrine, they've tested that recently. What you need to know the work product doctrine. And what they tested, the subtlety they tested is that documents or other intangibles by an attorney for a party in anticipation of litigation are going to be privileged. And there's two types of privilege, and that's been tested frequently. Absolute privilege, which is the attorney's mental impressions and theories, and qualified, which would be factual information that the other side could actually get if it turns out there's no other way to get it and it's significant and needed. Okay, now often they'll ask you something like, the defendant is demanding a mental exam. I demand a mental exam. I demand a physical exam. How do you get one? Well, you need to know the rules on when you can get a mental exam, when you can get a physical exam. And then when they say, well, suppose they could get one, how would they get it? And then the answer is you have a motion to compel. It's so obvious. A lot of people, they tested this, and a lot of people knew the answer, but they didn't write it down. Look, if you think you know the answer, if it crosses your mind, it's probably the right answer. Don't second guess yourself on the bar exam. All right, what's the overall statistics for civil procedure? And I discussed basically civil procedure versus contracts earlier. All right, 44.7%. It's 12 out of 12. In other words, it's the least likely subject. It's the most infrequently tested subject of all of them. Now, I want to go over something that you taught this in law school, and most people know it, or they think they know it, but they're missing something, and they don't do it right, or they know it and they don't do it correctly in the bar. The issue will be, did the court lack jurisdiction? The fact pattern will give you an out-of-state resident that had some kind of contact with the state. Now, the first thing you have to do Here's your approach. You have to begin with the traditional basis for jurisdiction, personal service in the state. Even if there's been absolutely zero contacts, none, no contacts. Well, there has to be one. Let's do for personal service, because let's say there's been no contacts and you want to get someone, you follow them, and then they make one step into the state, you serve them in the state, bingo, personal service in the state will do it. They can also consent. You can claim that you have personal jurisdiction. And if they don't object in their first answer to the court, then it's waived. Or there could be a forum clause. Or they could be domiciled in the state, and if they are, we can serve them anywhere. But we still have to serve them, of course. So that's traditional basis. And what you have to do is go through each one, discuss it. Does it apply? Next, you must discuss long-arm statute, even if they don't give you a long-arm statute. In fact, it's rare they give you a long-arm statute. There are two kinds of long-arm statutes, specific and non-specific. Specific will detail and outline exactly when the state can exercise jurisdiction over an out-of-state resident. We'll say, well, if you hurt one of our citizens, then we can sue you. Non-specific, such as California's is a non-specific, would be to the extent of due process, which means the test in international shoe. So one way or the other, your next head note has got to be the test in international shoe, your minimum contacts analysis, fair play, substantial justice, and so on. And there's wide flexibility on how you can do that analysis. The main thing they want is make sure every contact is duly noted and discussed in your book. All right, now, when all is said and done, what will happen is you'll have a certain number of contacts. And then the question is, well, is that enough? Well, what you should do is you should discuss, do we have enough contact for general jurisdiction, or do we have to go to specific jurisdiction? So if you have continuous and extensive contacts, then you get general jurisdiction. You treat them like they're in state. But you know what? You never, ever, ever have enough contacts on a California bar hypothetical to give you general jurisdiction. So then the next thing you have to do is you have to say, well, let's look for specific jurisdiction. In specific jurisdiction, we look for a nexus or connection between the harm and the contact. All right. Now, sometimes they'll say that Rita asked for dismissal on the basis of preclusion. And then you say, well, what do I want? Res judicata, collateral estoppel, what do they mean? And generally, you need to go through both. Now, let me give you a hint. For res judicata to work, you have to have the same parties in both lawsuits. So that's to be two lawsuits. So what you do is you set up, what was lawsuit one? What were the parties in lawsuit one? Let's say it was X versus Y in lawsuit one. Bob versus Mary in lawsuit one. Then lawsuit two, for res judicata to work, lawsuit two must also have X and Y, Bob and Mary. Unless you have anybody, if you have anybody else, Bob versus anybody else, Mary versus anybody else, res judicata won't work. So you see, all you have to do is look, do they have the same parties? If they have the same parties, all right, we go to the same claim. There's a big split between the federal rules and California rules. In the federal rules, we analyze same claim by same transaction or occurrence, whereas California is a primary rights jurisdiction. Now, if you need more than that, you can go back to our lectures. Any competent lecture in this area would discuss it. Any competent outline would also discuss it. If you're vague about it, go back to a lecture. All right. Then you need a valid final judgment. That's almost always there. On the merits, that's almost always there. So res judicata, same parties, same claim, valid final judgment on the merits. Nail it down right now. Maybe practice a few. Go on the internet, you'll find all kinds of things about it. Now, collateral estoppel. What they mainly test is this so-called non-mutual offensive. And that's where somebody that was not in the prior lawsuit wants to establish liability against someone who was a party in the prior lawsuit. So again, we have two lawsuits, lawsuit 1 and lawsuit 2. And we look, well, who are the parties in lawsuit 1? X versus Y. Now, the big rule, there are many, there's a number of rules, you can get them down, but the big rule is the party against whom the collateral estoppel is being asserted against must have been a party in the prior lawsuit. You got to understand that, you know. Go back to a lecture if you don't understand that. What that means is if lawsuit 1 has X and Y, the new defendant in lawsuit 2 for collateral estoppel to work must be either X or Y. If it's anybody else, if it's Z, anybody else but X or Y, collateral estoppel won't work. You see, now, you need to know how to do this in your head for the MBE. So this is not something that you want to just give casual notice to. I want you to nail this right now. Okay, finally, pleading. If they ask about pleading, let's just run through it quickly. The old standard was called notice pleading. You just needed a short, plain statement showing that the party is entitled to relief. That was led to all kinds of abuses by attorneys being conclusory, where they'd say, negligence is a breach of a duty of care, actual cause, proximate cause, etc., etc. They'd list the elements and say, here there was a duty, here there was actual cause, here, you see, that's conclusory. And the federal judges got sick and tired of it. So basically, they increased the standard to what is now called factual plausibility. And what that means is there has to be enough facts to cross the line between possible and probable. The judges specifically said, we will not accept conclusory statements. So when your professors say no conclusory statements, it doesn't stop there. If you're going to practice law all your life, you better not do conclusory statements. Analyze. And again, if you don't know what I mean by conclusory statement, please work on that. Now in California, we have code pleading. In some of the case law where they talked about factual plausibility, they said, but we're not going all the way to that draconian California code pleading. Why? That would be too tough for most lawyers. And that draconian code pleading means you need to plead sufficient facts for each and every element of your cause of action in order to state a claim. Now, the way they'll test pleading is there'll be a 12b6 motion, or in California, a demurrer. The 12b6 motion will be motion to dismiss for failure to state a claim. And that means what you have to do is look at the sufficiency of the pleadings. Okay, so that's civil procedure.